The state-by-state assault on women's rights and the Constitution by Republicans face an important challenge on Wednesday in Phoenix, where plaintiffs in a federal lawsuit are trying to block an extreme Arizona anti-abortion law from taking effect next week. The law, signed by Governor Jan Brewer in April, pushes Arizona to the forefront of a group of states that have recently moved to impose new restrictions on legal abortions based on medically dubious ideas about when a fetus can begin to feel pain. Arizona has set the earliest deadline in the country, while other states have forbidden abortions more than 20 weeks after fertilization. Arizona bases its time limit on a woman's last menstrual period, outlawing abortions after about 18 weeks from fertilization. Doctors convicted under the law would face up to 6 months in prison and could lose their licenses. Janet Cripps, a lawyer from the Center for Reproductive Rights, which brought the case with the American Civil Liberties Union and 3 Arizona doctors, took less than an hour to make an elemental argument before Judge James Teilborg of the United States District Court in Phoenix. The gist of the argument was that the Supreme Court in Roe v. Wade has forbidden states to ban abortions before viability, the point at which a fetus can survive outside the womb. That is usually about 24 weeks, but it is determined in individual cases by a doctor. States may try, within limits, to encourage women having abortions before then, but they may not deprive a woman of her fundamental right to choose an abortion before viability. Since this is settled law, upheld by the Supreme Court in subsequent cases, Judge Teilborg should not find it hard to make the right call. But the plaintiffs could not have been encouraged by his line of questioning on Wednesday morning. He began by asking Ms. Cripps irrelevant questions about which abortion procedures might be involved and the relative frequency of each. Then he lectured her for what he suggested wrongly was a lack of compassion for the unborn. He said he had read the plaintiff's affidavits and had found that they reflect profound compassion and concern for their patients, the women, and presumably the fathers. However, he added, I didn't find anywhere in those affidavits any expression of concern by the plaintiff's physicians for the unborn child, or even a hint of concern on their part. Given that silence on that part, the judge said, and given the silence in your own presentation, doesn't that underscore the legitimacy of the state's regulatory action out of concern for the unborn child? As should be clear to the judge, Arizona's new law is not a regulatory action. It's a ban with severely limited exceptions only in extreme emergencies. It denies a fundamental right to all Arizona women and puts in danger those who might want to carry a wanted but complicated pregnancy to term. The overwhelming number of abortions occur well before 20 weeks. Later, abortions mostly often involve severely troubled pregnancies that pose risks to a woman's health or life. A woman can develop life or health-threatening medical problems late in her pregnancy, and because fetal abnormalities often cannot be diagnosed before 20 weeks, the new laws may leave women feeling rushed to have abortions before then, or if they miss that window, they may be forced to wait out a dangerous pregnancy or to deliver a child who will quickly die. Roe versus Wade is still the law of the land, however. Arizona's politicians may wish otherwise. Its new law is more a product of right-wing politics than a supposed concern for women's health, as demonstrated recently when the Maricopa County Attorney, William Montgomery, clearly playing to the voters, filed a legally baseless motion asking the court to appoint a lawyer to represent the unborn in this case. Judge Teilborg respected the motion. We hope he takes the next step and blocks this harmful law from taking effect. first.
Ja, das muss ich first.